As far as family law practice orals are concerned, first and foremost, we looked at marriage and divorce, and according to the case of Hyde versus Hyde, defined marriage as a union between a husband and a wife with the exclusion of all the others. So we understand that under Article 31, the Constitution gives us a right to get married, and it gives us rights to marry, but also you must understand enjoy the same rights during and on the dissolution of marriage. So basically, the right to marry is provided for under Article 31, which basically provides that people of adult age or people of 18 years can come together and found a family. So we looked at types of marriages recognized under Ugandan law. We looked basically at customary marriage. We looked at under the Customary Marriages Act. We looked at church marriage, the ones which happen in church, and also we looked at what we call civil marriages, the one that are administered by the registrar. So you have to understand the requirements of each type of marriage. That, for example, if you have a church marriage, it must be under a licensed church, and also it must be under a licensed minister, but also there must be the reading of banns for us to have a valid church marriage. Then also looked at customary marriage, that this is marriage which is in line with customs of the African community. So we basically have the case of basically Juliet Namaza and Ivan Chuwa. The case basically they had challenged the marriage that because those people belonged into the same clan in Uganda, and of course the court came and stated that because they were under the same clan, they were not allowed to contract a valid marriage. They were not allowed to contract a valid marriage under the customary marriage or under the customs of Uganda practices. So we also looked at Islamic marriages. We understand that Islamic marriages are potentially polygamous, which are always governed by the Muhammadan Act. I also looked at, of course, church marriages are also potentially polygamous, but also what you have to understand that if you contract a valid customary marriage, then you cannot go into a church marriage or maybe a civil marriage. That second marriage, or which is called the church marriage, is going to be potentially an illegal marriage, because we have a subsisting customary marriage. So once you opt for customary marriage and you want to contract another second marriage, then you must only keep it under customary law, but you can't mix customary as well as church marriage, because the church marriage is going to be invalidated. So basically those are types of the marriages, and those are the requirements you have to achieve for you to have a valid marriage. Under the civil marriage, you have to give a notice to the registrar always for 21 days notice, and also this notice can be waived by the minister if you have applied to the minister and you have a sufficient ground, and then this notice can be waived. So we also looked at celebrating a civil marriage, legal requirements, and role of the registrar of marriages. So basically, role of the registrar of marriages, he issues a notice of marriages, and this notice must be for 21 days. But also, in case there is any caveat for marriage, it can be lodged on the registrar. So basically, the role of the registrar of marriages, first and foremost, he officiates marriages which are civil marriages. Then secondly, he also issues the notices of this marriage. And secondly, if you have a caveat against a civil marriage, you can also lodge them against the registrar. So we looked at celebrating a civil marriage, which must be celebrated between 8 a.m. to 4 p.m. in the office of the registrar or any other place which has been allowed by the minister. So the legal requirements, there must be 21 days notice. Parties must be of mature age. There must be consent of the parties for us to have what we call a civil marriage. Then after that, we shall see procedure for acquiring a license for a place of worship and celebrating a marriage under special license, legal requirements and procedure for acquisition of special license. So basically, if you want to conduct a marriage at the beach, you want the minister to officiate your marriage at the beach, you have to apply for a special license from the minister to have this marriage conducted at the beach. So if you have been asked an oral question, for example, how would you advise your client to conduct or have the marriage celebrated at the beach? That means you can apply for a special license to proceed to have that marriage at the beach. Rights and duties of married people. The rights and duties of married people, one, we can see that consummation, right to have children, right to keep stay in matrimonial home, right to have children. You can even be allowed to use your spouse name. So basically, the rights and duties of married people which accrue when there is a valid marriage. Then 7, stoppage of unintended marriage celebrations, the law procedure and legal requirements and the Marriage Act and other procedures. So in church marriage, if there have been bans which they have started reading, you can proceed and stop those bans. You can write to the registrar, basically stop those bans. Then as far as the registrar is the civil marriage is concerned, basically you have to issue a notice. You have to lodge a caveat to the registrar, stop those marriages. So basically the process of stopping a civil marriage is by issuing a caveat against that marriage. And then for the church marriage, you have to proceed and stop those bans by writing a letter to the ministry and attaching the documentary evidence and which grounds you are stopping that marriage. Nullity of marriage, the law grounds procedure for seeking a declaration of nullity of marriage and the resultant decree of nullity, necessary legal documents. Basically here we looked at the nullity of marriage. So you can nullify a marriage which is void ab initio. So for example, if you have acquired a monogamous marriage, like church marriage, when there is subsisting customary marriage, that means that marriage can be nullified under the ground of having a subsisting marriage. So that can be one of the grounds of nullifying a marriage. And then also have other grounds, for example, permanent impotence, the marriage where there was no consent, marriage which was obtained by fraud and misrepresentation. All those ones can be nullified because those ones are also looked as marriage which are void ab initio. So you can nullify a marriage which is void ab initio. Then from there we looked at first and foremost the grounds procedure for seeking a declaration of nullity and resident decree of nullity. You proceed by a petition, which is always a verified petition, to have the marriage nullified. Then void and voidable marriages. When we talk about a void marriage, is the marriage which is invalid at the very beginning. It's void ab initio. So these ones are the ones you proceed to do what? To nullify the marriages which are void at the very beginning. Then voidable marriages are the ones which can be repudiated by the affected party. For example, if you did not give consent and now you want to give consent, that becomes a voidable marriage. So it basically means that the affected party has the option to give that consent in that marriage. So that's basically what we call the difference between void and voidable marriages. Whereas the void marriage is invalid at its beginning, it cannot be rectified. It basically means that voidable marriages can be given effect by the affected party if he or she opts to stay in that marriage. Then separation, we looked at basically separation by agreement, features, terms and conditions and meaning of each preparing a separate deed. So basically when you're preparing a separate agreement, first and foremost you must have the grounds of divorce to include adultery, cruelty and also desertion. But also what you have to understand about the separation agreement, we have the Damcaster clause and the non-molestation clause. So basically the non-molestation clause is the effect that you should not entice the other party during that time when you have agreed to stay separate. Then the Damcaster clause basically means that there is no sexual intercourse between you as parties but also as other parties. Then looked at judicial separation grounds, procedure, form, remedies for the parties drafting a petition for judicial separation. So basically, judicial separation, you must have grounds of divorce, include desertion, cruelty, and also then you proceed by petition to court to apply for separation. So what is important for you to understand about judicial separation? Of course, you must also pray that there is no collusion, condonation, and connivance, which we can call also bars of divorce, but this one can always last for 2 years or more. Then looked at the divorce, dissolution of marriage, grounds for dissolution of each type of marriage, procedure, forum, and this legal documents, drafting of petition for dissolution of marriages. So we also proceeded to draft a petition for marriages. You can divorce any petition for divorce any marriage as long as you have the grounds of divorce under the Marriage Act. So these include adultery, cruelty, and desertion, and which have been discussed, of course, in the case of FIDA versus Anthony General, where the court stated that all these grounds are all available equally to all parties in the marriage in light of Article 31, which basically speaks to the effect that all people in the marriage enjoys equal rights. So it basically means that either the husband or wife can all go and opt for what we call dissolution of marriage. Then also looked at first and foremost, you can dissolve a customary marriage, you can dissolve a church marriage, you can dissolve a civil marriage, and also you can dissolve an Islamic marriage. But under Islamic marriage, you also have fasak, tarak, as also modes of dissolving those marriages. We also looked at absolute and discretionary bars to divorce. So basically, the absolute and discretionary bars to divorce, we mean that we have bars to divorce, which we talked about, connivance, condonation, and also connivance, condonation, and also collusion. That these ones, if you're going to divorce, then you must not have these grounds. There must not be the wife and the husband must not have agreed to do an act to end that marriage. And also, if I committed an act and you forgave me, that means you have there was forgiveness. So you can't rely on that very ground. So that becomes condonation. You condone that act. So you have to also understand that once there is connivance, condonation, or collusion, then that one cannot be a ground for divorce. So before divorce happens, we have divorce. We also have decrenacy and divorce absolute. Basically, the decrenacy is for 6 months to allow these people where they have any remedies to reconcile. Then after that, we have decrenacy absolute, which basically dissolves the marriage if the people fail to reconcile within 6 months. So matrimonial property, meaning relevant principles of law and application thereof to factual situations. We have the case of course, Julius versus Hope by him somewhere, which basically discussed matrimonial property. Yes, the court stated that parties are free to own any land which they have brought, which they were owning for the marriage, but the home which parties have agreed to call home, then it's equally owned among all the parties. So basically, the case on matrimonial property is that Julius Bahimbisibwe versus Hope Rwabinumi. So we start at jurisdiction in matrimonial proceedings. The jurisdiction is always if you have none, if you have a party one who is a non-Ugandan, it's always in the High Court. But if they are all Ugandans, we can go to Chief Magistrate subject to the subject matter in question. Then also we have burden and standard of proof in matrimonial proceedings. Section 10 of the Evidence Act states that he who alleges must prove, but also in matrimonial proceedings, important to understand that the burden of proof is on balance of probabilities. Then reliefs in matrimonial proceedings causes generally. Here we can see what remedies can you ask in matrimonial proceedings. For example, custody of children. Secondly, to own matrimonial property, and also to declare that the marriage, to accept the divorce of the marriage. Then also looked at ADR mechanism in matrimonial property, things like arbitration, mediation, and also reconciliation. So all the relevant legal documents, including decrees and rulings. We looked at how to extract decrees, guardianship orders, divorce orders, among others. ISCO issues in for matrimonial matters. First and foremost, where there are children, you must consider Section 3, which is the effect that in all matters where there are children, you must consider what is in the best interest of the children. And also have several cases on that principle, including the matter of precaria, which also emphasizes the best interest principle in all matters to do with children. So Part B, we look at children, meaning of a child and rights of a child. Of course, a child is defined under Section 1 of the Children's Act, and also I think and also the Constitution as any person below the age of 18. So we have rights of the children to include one, the right to stay with your parents, and the right to education, right to government programs like immunization, right to be, of course, you also right to be asked in instances where the matter is affecting the child and you are at the age of reasonable understanding, for example 12 years and above. The guiding principles in children matters, the welfare best interest principle of the child, and also considerations to take into account in order to determine the best interest of the child. So basically, when we talk about the best interest of the child, we are looking at Section 3 of the Children's Act, which basically provides that in all matters to do with children, then you must consider what is in the best interest of the child. And we also have in Article 3 of the African Charter, also Article 4 of the United Nations Conventions on the Rights of the Children. All these ones speak to the best interest principle of the child. So when they talk about the best interest principle of the child, we are talking about physical, emotional, and educational needs of the child. So basically, the court looks at who is in the most equipped to take care into the emotional needs of the child. The Family and Children Court, civil jurisdiction of the Family and Children Court, and the all powers. We looked at the Family and Children Court and also the Family and Children Court rules, where we looked at how do you apply remedies in this court for maintenance orders, for custody orders, for supervision orders, and how do you get these remedies from this court. So child welfare orders, custody, in case you want to get custody orders, you can proceed and apply for either interim custody order or maybe a full order. For the interim custody order, which always stays up to 3 months, we said you can apply by a notice of motion supported by an affidavit. Whereas for maintenance, in case you have a child and you want to get maintenance from the father, you can also proceed and apply maintenance of this child. So we also looked at the declaration of parentage. In case you want to declare parentage, you also have to proceed by complaint on oath, and then you apply for what? For declaration of parentage. But one thing you have to understand is that a declaration of parentage, once there is DNA proof, then DNA proof has been said to be conclusive evidence of parentage. And the effect of declaration of parentage is that it creates a bond between a father and a child, as well as because you automatically become the child of the father and you take about all the responsibilities of the parent. Then with a supervision order, in case you want to supervise the child, we can have an order of supervision, and basically here the social welfare officer can always come and supervise the child. Then exclusion order, where you want to protect a child from a parent, you can apply for what we call exclusion order. We also have care order. These care orders always apply in instances where, for example, you want to take a child in approved homes because they cannot admit a child if you don't have a care order, or maybe an interim care order. Contribution order. Adoption, we also looked at adoption, intercultural adoption, and also adoptions by Ugandan citizens. What you have to understand about adoption is first and foremost, what are the conditions for intercultural adoption, to include one, that the person has a certificate of good contact from Interpol. Second, you have lived in Uganda for more than 1 year. You have also had the child under foster for more than 1 year, and also you can prove that your country of origin is going to respect the adoption order, and also that you have a recommendation report from your country's social and welfare officer. So basically, when you have those ones, you can proceed and apply for intercountry adoption, and also it's by petition, which you must prove those conditions. Then also look at the guardianship. Guardianship is applied for only Ugandan citizens. Only Ugandan citizens who can apply for guardianship. So the only way you can apply for guardianship, you must be Ugandan citizens, and it's also by a petition. Supported by an affidavit. We also looked at foster care applications, where you apply to the district social welfare officer, and the applications are in the foster rules, whereby you apply by that application in the foster rules. Procedure and necessary legal documents in respect of each and every order provided for in the Children's Act. So basically, you have to understand that we have the difference between intercountry adoptions and also adoptions which are between Ugandan citizens. So if you're a Ugandan citizen and you want to adopt a child, you must prove that one, you are more than 25 years, and you are at least 21 years older than that child. Then secondly, that if you have a spouse, the spouse has consented. Then thirdly, that there are no any unknown relatives of that child, or if in case they are there, that they are not willing to take care of that child. And thirdly, that you have no criminal record to be able to be granted guardianship. So guardianship also proceed by petition and an affidavit in support. So also look at foster care, where any person can apply the social welfare officer, probation and social welfare officer, basically to be given foster care of the child. Due to as of foster parents, of course, they have to take care of the child, provide for educational needs and health needs, and also give the child home where to stay. So the role and powers of parents and guardians, under the Constitution, of course, Article 34 for rights of children, the parents have a right to stay with their children. So and they have also powers to consent to guardianship and adoptions where they are existing. They must give consent, and any consent which is obtained by fraud, misrepresentation, then that adoption or guardianship order can be revoked. And remember, if you're going to get for adoption or guardianship, you must prove to court that you have not paid any money to be given that adoption. So High Court, Court of Appeal, police, local government, the probation and social welfare officer, and the local government in ensuring the welfare of the child. So basically, the local government also have a role to play in ensuring the welfare of the child by implementing government programs like immunization, but also by supporting, advising for diversion. For example, in instances where we have a child offender. We looked at ADR, mechanisms for child welfare, as well as burden and standard of proof in children matters and ESCO issues. Then we also looked at Part C, which was succession and probate, letters of administration. We looked at how do you apply for succession. Basically, we talk about tested and tested succession. Tested basically means that the person died with no valid will, whereas intestate means that the person died. Tested means that the person left a valid will. Intestate means that there was no will. So determining beneficiaries of the deceased under testacy and intestacy and their rights. We have wills, types of the wills, features of a valid and privileged wills, and because of preparing of a will. So basically, when we talk about a will has been defined as a testamentary document. A will has been defined as a testamentary document, which basically shows how the property of the deceased is going to be bequeathed. Types of wills, you have privileged and unprivileged will. Unprivileged wills are the ones which we normally make, and they have the formalities under the act. But we also have unprivileged wills, the ones which can be made by army during the war. Then preparing a will must have two witnesses, the process of obtaining probate and letters of administration, at the time the appropriate forum and the necessary legal documents, drawing a petition for probate, letters of administration, the notice, the declaration, and probate and letters of administration. So basically, when you are going to acquire letters of probate, first and foremost, you must get the copy of the death certificate. You get a copy of the death certificate. Then after that, you proceed to apply to court. And when you apply to court, you draft a petition, and then after the petition, there must be a notice of the petition. Then after that, they carry out what we call identification, and then after you have been identified, the court can proceed to grant you letters of probate. So basically, you obtain death certificate, letters from LC1 introducing you, and then after that, you get a copy of the will. Then after that, you apply to court by using a petition. Then the court issues a notice. Then you are identified. After you are identified, then they can give you letters of probate. Whereas for letters of administration, you need to get a death certificate, inform the Administrator General. The Administrator General calls a family meeting. Then after the family meeting, the Administrator General gives you what we call a certificate of no objection. And then after getting certificate of no objection, you can proceed to apply by petition to court. And then after that, the court will carry out an identification, and then after that they can grant you letters of administration to that effect. Letters of administration with a will annexed. Letters of administration with a will annexed. It basically means that this will was not. If, for example, a person did not appoint an executor of the will, then that means you can proceed to apply for letters of administration where there was no an executor in that will. So you can proceed to apply for letters of administration where the will did not refer to the executor. So powers and duties of executors and administrators. So the powers and duties of executors and administrators, of course, these people have to manage the property in trust of the beneficiaries, but not basically, it's not their property. According to the case of Kauri Mbajana, these people must account to how they have used this property to their beneficiaries. So we have talked about the letters of administration with the will annexed, and I've said that where a person did not appoint an executor in the will, then that means you have to apply letters of administration in that very instance. Duration of probate or letters of administration, application for extension of the validity of probate or letters of administration, the law procedure, and the necessary documents. So you can also apply for the extension of letters of administration, or maybe you can apply for the time to file what we call inventory, or maybe if you have not filed an inventory in 6 months, then you can seek application from court to extend the time to file an inventory. We said an inventory basically shows all the property of the deceased, which you must file in 6 months after you have been appointed as an executor of the estate. Then after that, you will see you have to file what we call a final account. The role of the Administrator General in managing estates of the dead, powers and duties of the Administrator General, we can see if the person died intestate, you have to get certificate of no objection from the Administrator General's office. So basically, he also conducts a family meeting and also make sure that the property is very well managed. Caveats upon petition application for probate letters of administration, the law grounds forum during this caveat procedure and forum for urging the caveat suit for removal of this caveat and defending suits of this nature. So basically, when we look at caveats, we have looked at caveats. If someone has not lodged the notes of application of letters of administration or probate, and you have any reason to believe that that person shouldn't get letters of administration, you can lodge in a caveat, which is always supported by an affidavit in support. So basically, this caveat it has a specific form in the act, but must be supported by an affidavit. Then after that, what you have to do is that in case you want to remove that caveat, you can proceed by a plaint by proving the assertions in the caveat, and then the court will determine whether to remove that caveat or not. So the grounds of lodging the caveat could be one, if the person declared himself to be an executor but is not. Secondly, if the property was not declared. Thirdly, if maybe some of the beneficiaries were not declared. So those can be some of the grounds under which you can lodge a caveat to the grant of letters of administration, or maybe the grant of letters of probate. Then have probate receiving, the law procedure, conditions, forum, and legal documents. So basically, when we talk about probate receiving, what we mean is that you have letters of administration or probate from a different country, for example, like Kenya, but the property is here in Uganda. So basically, what you have to do, you have to go through what they call the process of probate receiving. So basically, this probate receiving, you apply by the ordinary letter to the register of the court, and the register of the court, after payment, you attach the copy of the letters of administration and you pay the appropriate court fees. And then after that, the registrar endorses the letters of administration, and then they are given effect, and then you can proceed to manage that property in Uganda. So we looked also at ADR, or the relevant legal documents in this area, and estate planning using the will and trust as vehicles of estate planning, structuring a will on one hand and a trust list on the other hand for purpose of estate planning. So basically, we looked at how do you make a will, and basically we talked about how a will is a testamentary disposition, which basically bequeaths the property of the deceased, and the will takes effect upon the death of the person. So a will must be in a written form and must be signed by 2 witnesses. So basically, the contents of the will is dated. The will has the property, it has the children, it has the executor, and also it has witnesses. So basically, that's the contents of the will. And you have to understand that a will can be invalidated by a marriage. If you make a will and you later marry again, basically means that you have invalidated the will you make. Then a codicil basically makes amendment to the will. So basically that's what we call a codicil, which basically makes an amendment to the will. So when you talk about estate planning basically means the way of planning that when you die, your estate is not mismanaged, but it's properly handled. And the tools to be used in estate planning, one, you have a will and also a trust. So you can choose to bequeath your property through a will, and remember that you can only bequeath property that belongs to you. Then after that, we looked at trusts, and trust can also be used as tools in estate planning as far as bequeathing the property is concerned. So trust, you have to appoint a trustee, and you invest that property into that trustee, and he can manage it on behalf of the beneficiaries. Then ISCO issues include, of course, due diligence, not overcharging client, the best interest principle of the children, and also making sure that you act with instructions. Then part D basically we looked at revocation of letters of probate, and under section 230 we are looking at there are very many grounds under which a person can revoke letters of administration, to include one that there is just cause. Just cause can take the following forms. For example, when there is a true fact, when the procedure for acquiring letters of administration or probate was invalid, when there was mismanagement of the property, when there was failure to file an inventory, or maybe when there is failure to file a final account, and also when the letters have been rendered inoperative, or maybe what we can call rendered invalid, or maybe inoperative. So those are some of the grounds where we can see the one can use to apply for the grant or revocation of letters of administration. So procedure is always by you can revoke always using a plaint to revoke those letters of administration. And we looked at the documents for revocation of probate letters of administration before the High Court, which is always, we looked at both short-term and long-term remedies. Short term, we say that you can lodge a caveat, you can go for administration pendulite. Basically, a person is appointed when the letters to manage the estate during that litigation process. We have temporary injunction, interim orders, as well as ex parte interim orders. So from there, we also looked at long-term remedies, which include a plaint to revoke the letters of administration, and here you can seek permanent injunction. You can seek that you be put on the letters as an administrator. You can as well seek that the court grants you damages for the loss that was caused by the person who was given these letters. Then from there, we looked at grounds, procedure, and necessary legal documents for revocation of probate and letters of administration before subordinate courts. Basically, here we're looking at Chief Magistrates Courts. So the Chief Magistrates Courts, basically what happens is that there must be a citation, and then after the citation there must be a caveat, and then after the caveat there must be a plaint supported by a summary of evidence. So basically that's what are provided for under the Administration of Small Estates rules, which basically provides for that procedure, especially Rule 17 of that Small Estate rules. Basically that's how you revoke letters of administration and probate under Small Estates. And what you have to understand is that all this procedure is provided for by the law, and then you must have the grounds under Section 230 of the Sections Act, which amounts to just cause, which include true allegations, or maybe fraudulent procedure, when you have failed to file an inventory or final account, or maybe when you have mismanaged the property, or the letters have been rendered inoperative, as some of the grounds of revoking the letters of administration or probate. We looked at revocation of grants, interim and final reliefs, where we have looked at interim remedies to include caveats and temporary injunction, and among other final reliefs to include revocation of letters of administration. Any other mechanisms, we can have reconciliation because these are family members, mediation, and also negotiations, among others. Ethics, best interest principle section C, since you're dealing with student matters, make sure that the children matters are at the heart of your interest, and you consider their matters, and also not overcharging clients, avoiding conflict of interest, among others. So basically that was it for what we expect in our family law orals. Basically, if you just prepare for this document and you fill in the details, then I believe that there's no question that's going to come in outside this scope. So basically, I just simplified the work for you. If you have just understood it the way I have put it, then it's going to be very easy for you to make preparation. But once you understand the principles, then the orals really become the very easiest and most enjoyable exam you can ever have at LDC. So basically, in case you want a mentorship program, we have a mentorship program covering all campuses. We make oral preparation, we prepare for the final exams by answering past papers. So in case you need something like that to help you to become prepared and you pass the bar at a very fast sitting, please contact me on 07567678284. 07567678284. Please only contact me if you want to join that mastermind group, whereby we have an online program and we cover students from all the 4 campuses. Please, we remain the Pass the Bar team. We wish you success in your oral exams, and if I can do it, surely you can do it. Please have a blessed day, and wish you success in your oral exams and your journey at LDC.